Awesome. All right, so good evening, everyone. I know people will continue to trickle in likely, but we'll get started right now anyway. So my name is Hillary and I work in the MSW field office at Laurier's Faculty of Social Work. And I'd like to welcome you to this evening's session, our final workshop number 5 of the legal series this month. This one on the topic of consent and capacity, healthcare consent, wills, and powers of attorney. I hope I got that right. And if I mixed up any of that, we'll have our speaker correct me in just a moment. Again, a final thank you to Waterloo Region Community Legal Services for their time and expertise in delivering these sessions throughout the month of February and this one going into March. If you have any questions about the series, maybe you didn't get the chance to attend all of them, please reach us at mswfield@wlu.ca and we can provide you with maybe additional resources that were sent to us after each session, some links to the recordings and so on. So please don't hesitate to reach us if you have questions about the series. So let's acknowledge the land in which we are situated. The Faculty of Social Work is on Laurier's Kitchener campus, and that's where I am this evening as well, in Kitchener, Ontario. Laurier is on the traditional territory of the Neutral, Anishinaabe, and Haudenosaunee peoples. On that note, I wish everyone a wonderful and insightful session this evening. I'd like to now hand it over to our speaker, Shannon Down, and first say a few introductory words about our speaker. So bear with me just one more minute, Shannon. I'm sorry, I'm taking a while here. So Shannon is the executive director and a lawyer at Waterloo Region Community Legal Services. She practiced employment law and mental health law in private practice for a number of years before joining the legal clinic in 2013. Shannon continues to have an interest in the area of consent and capacity law and mental health law, as well as a strong focus on social justice. Now I will officially hand it over to you, Shannon. Take it away. Thank you.
Thank you. Thank you for that great introduction and welcome everybody. So I'm going to jump in fairly quickly to sharing my screen. I have a slide deck I'm going to go through on the topics that we're talking about tonight, and I'm hoping we'll have a bit of time for questions at the end. If you do have a question during the presentation, you want to put it in the chat box, that's fine, or you can wait till the end and just raise your hand and we can take some questions then. And as Hillary mentioned, I'm going to make the slides available to her so that anyone who's interested in getting a copy of the slide deck as a Word document can do so after the presentation. So just bear with me 1 second. Okay. Okay, so so the information that I'm going to be giving you tonight is legal information. It's not legal advice. Every case is different. Please consult with a lawyer or paralegal about your issue if you have a specific question. We've already done the land acknowledgement. Thank you, Hillary, for that. So welcome. I just want to go through why are we talking about this? So as social workers, I think issues around consent and capacity come up frequently with your clientele. And as lawyers, these issues come up quite frequently with our clientele. If you work in the social services field, you may come into contact with a high number of people who are living with mental health issues, substance abuse issues, concurrent disorders, and also the aging population makes this a very relevant topic. So there's some main legislative sources that we draw upon for the information that we're going to be talking about tonight. Most of what we're talking about tonight is contained in these 3 acts: the Mental Health Act, the Healthcare Consent Act, and the Substitute Decisions Act. So Some just general legal concepts with respect to capacity. One really important one is that people are presumed to have capacity unless there are reasonable grounds to believe otherwise. That concept is captured in Section 2 of the Substitute Decisions Act and Section 4, Sub 2 of the Healthcare Consent Act. And also another important concept is that a person is deemed to be capable. This is sort of the legal test around capacity. If they can, first of all, understand the information that's relevant to making a decision about a proposed treatment and appreciate the reasonably foreseeable consequences of making a decision or a lack of decision about that proposed treatment. Some more capacity concepts. Capacity depends on treatment. Capacity depends on time. And there's no specific age of consent for healthcare decisions. So as long as a youth has capacity, they can make healthcare decisions. When I say capacity depends on treatment and time, what I mean by that is you may have a person who's capable of making a decision about a certain simple kind of treatment who may not have the capacity to consent to a more complex treatment. So for example, someone may be able to consent to receiving a vaccination, but they may not have the capacity to consent to having major surgery. And capacity also depends on time. So someone can have capacity at a particular point in time, and then later lose that capacity, and then later again regain the capacity. So if you have someone who, you can have people who move in and out of being capable. So who determines capacity? It's usually the healthcare practitioner who's proposing a treatment, who makes a determination of whether or not the patient is capable. Capacity can also be determined by a professional capacity assessor, and there's a process you can request through the public guardian and trustee to have a capacity assessment done, or you can privately engage with a capacity assessor to have that done. But often in the practical day-to-day sort of context, it would be the healthcare practitioner. So it could be a nurse practitioner or a doctor or a psychiatrist. Why is capacity important? It's important because all treatment requires consent except for emergencies. And if someone is incapable, then consent has to be obtained from someone else. So that's where something called the SDM, the substitute decision maker hierarchy, comes in. And if someone is under 16, then their substitute decision maker would be their parent or a person standing in place of a parent. So this is the hierarchy. So there's a hierarchy that is listed in the Healthcare Consent Act in Section 21, and it's a hierarchy of who has the highest right to be a substitute decision maker. So when a healthcare practitioner is dealing with an incapable person and they're looking to get consent from the substitute decision maker, this is the list of people that they need to go to. And you start at the top and then work your way down. So the first would be a guardian of the person with authority for health decisions. That's someone who's appointed by court. And that would be if there is such a person, then they have the highest authority to be the substitute decision maker. If not, you move to number 2, which is attorney for personal care with authority for health decisions. That would be someone who is designated under a power of attorney for personal care to make healthcare decisions for someone. So that would be the second highest person. Next, we would have a representative appointed by the Consent and Capacity Board. There's a special process for that to appoint someone as a representative. I'm not going to get into the details of that right now. It's just important that you know that that exists. Next would be a spouse or partner. Next would be a child who's over 16 or a parent or Children's Aid Society with, so a person with right of custody. The parent in number 5 refers to someone who has custody. If there isn't a parent who has custody, then the parent with right of access would be next in line. And then brother or sister, followed by any other relative. And then lastly, the office of the public guardian and trustee. So the office of the public guardian and trustee is known as the SDM of last resort. So generally speaking, they don't get involved unless there's nobody else in this list who can make a decision. However, they may also get involved if you have conflicting SDM. So if you have more than one substitute decision maker who's at the same level. So let's just for an example, let's say siblings who are making a decision for their mother who has, let's say, just as an example, dementia. And they don't agree on the proposed treatment. One consents maybe and the other one doesn't consent, then the office and the public guardian and trustee would be called upon to make a decision until that situation gets sorted out. So I previously mentioned the Mental Health Act. If you're a social worker who's working in a hospital setting, particularly if you're working in a psychiatric setting, you'll become very familiar with this act. It governs all psychiatric facilities and admissions. It also governs something called a community treatment order. So essentially, and this is we're just going to do a very high level review of this because there's a lot of, you could do a whole presentation just on the provisions of the Mental Health Act, but at a high level, if someone is a danger to themselves or to others, then they would be formed under the Mental Health Act. And there's a tribunal known as the Consent and the Capacity Board, which has the authority to hear appeals arising from both the Mental Health Act and the Healthcare Consent Act. So under the Mental Health Act, some of the common forms that you might run into, it's Form 1, that's an application for a psychiatric assessment. So often when people are first admitted to hospital, it would be under a Form 1. And then there's something called a Form 3, which is a certificate of involuntary admission. So after someone's been assessed under Form 1 and found to be incapable and requiring treatment, then if that person doesn't consent to that treatment, then a Form 3 would be issued. A Form 49 is a notice of intention to issue or to review a community treatment order. Just briefly, a community treatment order is an order which allows someone to live out in the community, but where they're not consenting to treatment, but it allows treatment to be given to them even when they're not consenting. So sometimes you'll have psychiatric patients who aren't held in the hospital, but they're under a community treatment order, which means that they would have to check in with a member of a community a mental health community team member and get some kind of treatment, potentially medication or other kinds of treatment. So when someone is in a psychiatric facility, they have certain, and they're not consenting to treatment and they've been found incapable of treatment or they're being involuntarily held, they have certain rights as a patient. So the process that occurs is that if someone is formed, if they're held in hospital, they need to be provided information about their rights by a rights advisor. And the rights advisor, after giving that information, also must help them apply to the Consent and Capacity Board for review of the order if the patient so wishes to do that. And a person who is subject to a community treatment order also has the right to appeal to the Consent and Capacity Board. Rights advisors exist at all major facilities that have psychiatric patients. And there's an office called the Psychiatric Patient Advocacy Office that hires the rights advisors and oversees that role. So a little bit about the Consent and Capacity Board. It's possible if you're working in this area, at some point you may be called upon to be a witness before the Consent and Capacity Board. It's a fairly informal tribunal. It's a panel of, generally speaking, 3 members. 1 member is a lawyer, 1 is a psychiatrist, and one's a community member. The hearings happen within 7 days of an application being made, and decisions are made within 1 day of the hearing. That's for generally speaking. There are sometimes exceptions to that for complex cases, but that's the general rule. So I mentioned previously the Office of the Public Guardian and Trustee. Again, you may, if you're assisting people who are living in the community who have problems with mental health issues, you may end up interacting with the public guardian and trustee. Sometimes they're the only option to make decisions for an incapable person. That's usually when someone doesn't have a power of attorney and they don't have any family or relatives who can step in and make those decisions for them. So the public guardian and trustee can make healthcare decisions for an incapable person, and they can also make decisions related to property. The PG&T is a provincial government agency. If you have a client that the public guardian trustee is involved with, the client will have a caseworker assigned to them at the public guardian and trustee. And you may need to communicate with the caseworker from time to time or help your client to advocate for themselves with the PGT. So if someone is found, for example, to be incapable of making their own financial decisions, then the caseworker may do things like pay their rent directly. They would receive that person's social assistance checks. They might provide the incapable person with an allowance, and they have some flexibility around some of those tasks. And sometimes the person who the PGT is acting for is unhappy about how they're handling that role, and they want changes. So you may be involved in helping them to advocate for those changes. So as I mentioned, the PGT gets involved usually when a person doesn't have a valid power of attorney for personal care and has been found incapable of making healthcare decisions, or they don't have a power of attorney for property. And either they've been found incapable by a healthcare professional or a capacity assessor, and the person may or may not be in a hospital or a psychiatric facility. So sometimes the initial assessment might be done in a hospital or a psychiatric facility, but then eventually the person is released to the community, but they may still have an order that says they're incapable of certain types of healthcare or property decisions. So I'm going to move into talking about power of attorney documents. So a power of attorney document is a legal document that gives someone else the power to act on your behalf. And we have 2 types in Ontario: a continuing power of attorney for property and a power of attorney for personal care. So the power of attorney for personal care is a document where you name someone else to become your attorney to make personal care decisions on your behalf. And that would happen only under the circumstances where you're mentally incapable of making those decisions yourself. So it's not an attorney doesn't refer to a lawyer. It's just a person that you trust to make those decisions. So it might be someone who's a family member or a friend. And if you became incapable at some point in your life, that person would be able to make personal care decisions about your healthcare, medical treatments, potentially your diet, potentially your housing, your clothing, your hygiene, your safety. So all those sorts of decisions. The other type of power of attorney is one for property, and that's a document where you name someone to essentially step into your shoes to make financial and property decisions for you. They can make decisions, manage property on your behalf, and depending on how the document is drafted or written, they would have the authority to act for you both when you're capable and when you're found mentally incapable, or only when you've been found mentally incapable. And if you're wondering, like, why would you want your power of attorney to act for you if you were still capable? Sometimes it's because maybe if you have to leave the country for a prolonged period for work or for travel, and you want someone looking after your property in Canada while you're away, you might have a power of attorney where you provide your power of attorney with that power to act while you're still capable. Most often people use the power of attorney for personal care to have someone step into their shoes when you've been found mentally incapable. So, someone, if let's say, as you're aging, you name someone as your power of attorney for property. If you lose capacity, that person can pay your bills for you. They can make financial decisions in terms of investments, your real property, your real estate, etc. So why is it important to know about the substitute decision makers and powers of attorney? If you're dealing with a client who's incapable, you may have to try and figure out who their substitute decision maker is so that you can consult with them. However, it's really important to remember that the presumption of capacity operates. So you should only deal with a substitute decision maker when your client is truly incapable. So some decisions may be within their capacity, and wherever possible, you should try and get the client to make those decisions on their own. But if you're aware that that they may be incapable or that they do have a substitute decision maker who's been acting on their behalf, you may need to interact with them. It's also important to be alert for breach of duties by a substitute decision maker or power of attorney, and potentially advocate on behalf of the client. So sometimes the substitute decision maker is not making decisions. They're letting things slide. They're not, or the power of attorney is not making decisions, and that's putting a client in harm's way. And you may need to take steps to make sure that the client's safety is looked after. So that can happen. Or sometimes people are in a position where they're being abused by a power of attorney or a substitute decision maker, either financially or physically, and you want to be alert to those situations as well.
Hi, Shannon. There's a question whether this information is applicable to all of Canada or just to Ontario.
So this information is applicable to Ontario. So each province has their own version of the Substitute Decisions Act and Mental Health Act and Healthcare Consent Act. So those are provincial laws. So most provinces have similar laws, but there may be some differences. So if you're practicing in a different province, you would want to find out what the specific laws, the similar laws in those provinces, what they say. Okay, so I've created a list of some online resources. So this will be in the document that I'll send around afterwards. These are just some general resources. They're not necessarily specific just to this area, but CLEO, so Community Legal Education Ontario, has some great resources for frontline workers on a variety of topics, not just on mental health and substitute decisions, power of attorney, but family law, employment law, human rights law, housing law, a number of areas. So that's a great resource if you're working with clients and they have legal problems and you want to find out some information that's specific to Ontario, up-to-date, reliable legal information. Another great source of information is stepstojustice.ca. Again, that's Ontario specific legal information. There's a lot of guided pathways. So one of the guided pathways that has been developed in Steps to Justice is there's guided pathways for doing a simple will, as well as power of attorney documents. So it basically, it's like a series of questions that a client would answer. And then at the end, a document is created that is a power of attorney document for personal care or for property, or a simple will. So it's a fantastic resource. Steps to Justice also has all kinds of legal information about family law, criminal law, housing, human rights, disability issues, immigration, so a wide range of legal issues. So it's a fantastic resource. I highly recommend it. I've put the website for some information about the Office of the Public Guardian and Trustee. There's a link for that. I also put a link to a resource from Speak Up Ontario, which is all about the substitute decision maker hierarchy, and has a lot of information about advanced care planning for people. So communicating to the guidelines on how to communicate to your substitute decision maker about what kind of decisions you want them to make. So that's a great resource. And then there's also a link to the Province of Ontario website with some information about the Psychiatric Patient Advocate Office, which I had mentioned in relation to the Mental Health Act and some of the provisions around the rights advisors that patients have access to when they're in a psychiatric facility. So I'm just going to talk generally about wills as well, just briefly. So I didn't put any slide deck pages together on wills, but the main difference, so sometimes people confuse the role of a will versus the power of attorney. And the easiest way to remember it is power of attorney documents are only valid when the person is alive. And the will, conversely, only takes effect upon your death. So there's no overlap. So if you have a power of attorney document that governs what happens when you're incapable while you're alive, you die, and then the provisions of your will come into effect. You may end up helping a client go through the process of creating a will. The Steps to Justice website that I've mentioned is a really good resource if your client is low income, can't afford to hire a lawyer to do a will. The guided pathway for doing wills on Steps to Justice is very good for someone who has a simple, who has a fairly simple set of circumstances and needs a basic will. If your client obviously has more resources, then I always recommend that if you're getting or drafting a will, that you go see a lawyer and get some legal advice. That's, optimal, but not everybody can afford that. So it's great to have the other option on Steps to Justice. The main purposes of a will, if say you're someone who's a fairly, modest means, you don't have a lot of property, you're either low income or living in poverty, you may still want to have a will because first of all, it names someone who is responsible for looking after your affairs once you die. That person is your executor or trustee under your will, and they would look after things like dealing with your landlord and giving notice to terminate a lease. They could help your survivors apply for Canada Pension Plan, survivor benefits. They could arrange for your funeral, pay off any debts that you may have, and distribute whatever assets you do have at the time of your death to the people that you've named as your beneficiaries under your will. So I always recommend to people, sometimes people think, well, if I don't own really any expensive property, or I don't have a lot of investments, do I really need a will? Still simplifies things after you die. If you don't have a will, if you die without a will, there is a process by which someone can apply to the Superior Court in Ontario to become an estate executor or trustee without a will. But that costs money, it takes time, and it's a reasonably complex process. So having a simple will where you just have very basic provisions naming an executor and trustee, etc., is better than not having a will. Another reason you may want to have a will, particularly if you have children, is that you can name a guardian for your children. It's important to know that when you name a guardian in your will for your children, doesn't mean that that person is automatically going to become the guardian. Ultimately, it's up for the court has to approve it, and it has to be there's a best interest of the child test that's involved. So you can suggest who you'd like to be your guardian, and chances are that'll probably be approved, but it's just it's important to know that ultimately the best interest of the child governs. I think that's about it. I've got our contact information, and we're reasonably early, so we have time for lots of questions. So I don't know if you want to open, you can put up your hand, you can unmute yourself, bring on the questions.
Thank you so much, Shannon. I'm going to stop the recording in case anybody has any more personal questions to ask.